I'm Russell Ford, founding partner of FordMurray, an immigration law firm in Portland, Maine, with clients throughout the United States. And we're shooting this video series to answer some common questions that come up from our clients, from folks in the industry who ask, what can we do if our H-1B wasn't selected in the lottery? Or what do we do if the H-1B just isn't available? Today, we're going to focus on really those non-immigrant options that are available when the H-1B just isn't. The primary ones you think about are TN, E3, H-1B1, because they all look very similar to the H-1B in the sense of they require a professional. The position has to require a degree, and the person has to have a degree in that field. But they're more limited in the sense the TN is limited to only folks who are citizens of Canada or Mexico. The E3 is limited to only citizens of Australia. And the H-1B1 is limited to only citizens of Chile and Singapore. And so you are fairly limited in those categories. But if you have an individual that holds a passport from one of those locations, looking at that alternative to the H-1B is your first step. What if they don't hold that passport? The next thing you look at is their resume. Does that resume make you say, wow, oh my gosh, this person is amazing. They are one of the top people in their field. I have to have them at my company. They've got all of these great publications and awards, and they've got patents, and they've done this, and they've just set themselves apart in the industry. If that resume, or if that resume is sitting in front of you and that's your candidate, you might want to look at the O1 Extraordinary Ability Visa. Maybe that's an option for you to look at, consider, and go if the H-1B just isn't there. What if their resume doesn't say that? Are you out of chances? Are you out of luck? No. There's still a couple of different alternatives that you can consider. One is the E2 option, where if they come from a E-treaty country and they have an opportunity, or there is an opportunity for them to set up a business through the E-treaty operations and establish their own entity, a little consulting business. Let's say you're in IT. And so you set up this person who's an SAP expert, and they set up their own little SAP consulting business. That consulting business contracts with your organization to provide SAP services. That's one particular way you could do it. But what if they're not from an E-treaty country? Then you start to think about the L1 visa. Is there an opportunity for my organization to send them outside of the US? Do I have branches in Canada, Mexico, the UK, Sweden, wherever it may be, where I can place this person for a year? Why a year? Because as you recall, the L1 intracompany transferee requires that person to work for your organization at an affiliated entity for at least 1 year. So if you could place them overseas, let them work for the organization, do duties that you needed in the US, maybe overseas, maybe fill a different role, work for that year, and then bring them back on the L1 intracompany transferee. The big advantage to that situation, as well as the E2 situation, is neither one of those has a cap. Unlike the H-1B, where you might be limited as to when you can file, how many folks you can bring in, the L1 provides a bigger opportunity for you to bring that person back anytime after that 1 year. It might be 18 months. It might be 17 months. Whenever it works out after that 12 months that you need that individual back, you can look at the L1 intercompany transferee. These are just a few of those non-immigrant options that you can look at. I know we threw a lot of alphabet soup at you today, so you might have questions. You might want to dig deeper into, do I have these options for my candidate? We offer free consultations. Give us a call, check out our website, shoot us an email, and we'll be happy to walk through any options that might be available to you and the candidate you're looking to hire. Thanks.